What every attorney needs to know about applying for and appealing a denial of their long-term disability claim. Long-term disability insurance companies don't always make it easy for attorneys who become disabled to get the disability benefits they deserve. After all, you purchased a disability insurance policy to provide you with peace of mind. But let me tell you the story that I hear from my attorney clients. Look, I need this disability income. I've got this lifestyle that I've got to maintain. And if I become partially or totally disabled, I want to be able to make sure that my benefits are there for my family. I never really thought I'd have to apply for my benefits, and I was hoping at some point that I would get better. But I'm having real problems and I just can't keep up. I can't continue to work or deal with my medical problems and function at home. This is a big problem. Is it time to apply for my benefits? The unthinkable, the unimaginable, and the unbelievable has happened to you. And probably you have no choice but to apply for your long-term disability benefits. But I don't want the disability insurance carrier to rob you of your peace of mind. Pre-planning and your application for long-term disability benefits. Now, many attorneys think that just because they went to law school or they deal with insurance companies every day, they know how to apply for and get their disability benefits without the assistance of an individual disability or ERISA disability attorney. Boy, is that wrong. There are many mistakes that can be made before and during the disability claim application process. These include a failure to understand crucial terms in your disability policy, like elimination period. What's the right date of disability? What's the definition of disability or own occupation? What's before disability earnings or post-disability earnings? What's other income? A failure to understand these terms and what monies can be deducted from your benefits, like the receipt of Social Security benefits, any personal injury settlement, or even a buyout of your practice, can come as a shock when it's too late to do anything about it. I find that people will not understand if they have a residual disability claim and the financial documents required to prove the entitlement to benefits and the amount of residual disability benefits, and a failure to understand what you've got to submit to prove your right to those benefits on an ongoing basis. Now, I also find that attorneys just don't understand how the term occupation is defined and what financial and practice information you're required to submit to document your occupation. You'd be surprised about what you've got to submit to document your occupation. And I find that people don't understand the interaction between their disability policies. You might have multiple disability policies and not understand how they interact. And there's a failure to understand the games that disability carriers play with your application, and a failure to have a strategy to defend yourself against these games before they start. There's nothing more crucial than your disability benefits and your health, so don't be a do-it-yourselfer. I have never had an initial application that I prepared and submitted denied, ever, because we do it right and we submit a shock and awe application. Denial of your continuing long-term disability benefits. Now look, just because the carrier started paying benefits, don't think they're merely going to continue to pay your benefits. You're going to have to submit forms, lots of forms, activity of daily living forms. Your physician is going to have to keep on filling out attending physician statement forms. These forms have to be completed properly and on time and consistently. Well, how about a situation where you're just not ready to stop practicing but you're losing income? You may be entitled to a residual claim. That's the calculation or payment of benefits based on your before monthly earnings and your post injury or disability earnings. What are those earnings? Depends on the terms of your policy. What financial documents do you have to submit? How often? These are things that I can help you so that you get the disability benefits you deserve. Now, there may come a time when you decide you just can't practice anymore, and you have to close it in a way that doesn't jeopardize your continued disability payments. I work with lawyers and other professionals in accomplishing that goal and keeping their benefits. Because look, carriers are not in the business of continuing to pay your benefits. They're looking for reasons to deny benefits. And just because you're being paid doesn't mean that your claim is going to be immune from scrutiny. Disability carriers target attorney claims or even certain diseases for termination. Don't set yourself up for a claim, a denial, or termination. Look, nobody can force you or the carrier into a lump sum buyout of your remaining disability benefits. There might be a time and place for a buyout, and any buyout should be in your best financial interest. I think there are many factors that have to be considered in evaluating the value of your benefits and what's right for you. Having an experienced ID or ERISA disability attorney who negotiates these kinds of claims for a living and who represents you in a buyout, I think, is key. You need to get the legal help you need now, because I don't pretend to practice in your specialty, and you shouldn't pretend to be a disability insurance attorney. We may both be attorneys, but this isn't Social Security law, personal injury law, criminal law, or any other type of law. It is as simple as that. ERISA is not simple. It's that simple. If you have a group disability policy, it's probably covered by the ERISA law. ERISA is a weird law, and it has a convoluted standard of review. So before you stop working or submit your initial application, you should talk to someone like myself who understands the ERISA disability claims process, the standard of review, and what it takes to file a winning application and to keep your disability benefits. Call me at 727-894-3188. I can represent you regardless of where you live in the United States and regardless of your specialty. I offer a free 30-minute policy review and a consultation. I've written a comprehensive book called What Every Professional Needs to Know About Their Disability Policy. I wrote it because I want professionals like you to understand what's in your policy, the games that carriers play, and what you need to do to get the disability benefits you and your family deserve. Call today at 727-894-3188 for a complimentary consultation.